your sentence enforcement supervisor has filed paperwork with the court alleging that you are out of compliance with your probation. Do you understand the question that's on the table today?
Yes.
Do you, all right, Ms. Dorsey, do you understand that you have the right to have an attorney represent you?
Yes.
And you're here representing yourself?
Yes.
Is that what you want to do?
No.
All right, you're wanting an attorney?
Yes.
What steps have you taken to secure the public defender's office or hire a private attorney?
I'm gonna hire a private attorney.
Okay.
I've already talked to one.
Well, I appreciate that, but that's not, my question was what steps have you taken, not what you want to do. What steps have you taken? What have you actually done to secure an attorney for this moment?
I've already went and talked to an attorney about the situation, and I just gotta go and make the payment. They already have copies of my paperwork.
Who is they?
The attorney that I went and talked to,
I appreciate that evasive answer, but that was not my question.
Virgil Brown.
Thank you. I don't understand why this is a problem. I'm asking you very specific questions and you're giving me roundabout the bend answers, and it's, I gotta tell you, like, you've already
I'm
done
just
this.
nervous, but I'm
Okay, well, I want you to listen to the questions I'm asking and I want you to answer those questions. So
Yes,
like,
sir.
when I say, who did you talk to? It's not an attorney, it's who did you talk to? What person did you speak with?
Yes, sir.
And I'm looking for Virgil Brown's office or Jody Sellers or whoever.
Yes, sir.
So I just need you to know that I'm already running thin with that.
Okay.
Why haven't you hired them for today, since today was the day of your hearing?
Because I didn't have the money to hire them for today.
Okay.
But I have it now.
All right. Ms. Rich, tell me, Deputy Director Rich, tell me, when was this noticed?
So we mailed it out on May 8th.
Is that the day of the incident too?
Yes.
All right, well then what I'm gonna do is I'm going to convert this from a revocation hearing into a probable cause hearing. Therefore, I will be making a determination today based off of a limited amount of testimony as to whether or not continued release is proper for this case.
Yes, sir.
But I will not be making a final determination on your case until a later date. So do you understand that I'm changing the particulars of what I'm going to be deciding?
Yes, sir.
That I'm simply going to be deciding whether to take you into custody at this time or not. And at the end of this hearing, I will make that decision.
Yes, sir.
Okay. All right. Well, that's going to be our limited. We're handling this as a probable cause hearing. You don't actually have the right to participate, but I'll let you ask some questions if you want. And so we're going to go from there. So Deputy Director Rich, you're already sworn. Ma'am, you can have a seat at that table there. And Mr. Shepard, are you participating in this
I
at all?
can be judge or?
Yeah, that'd be great. Just, again, I'm just looking for probable cause to decide whether or not custody is proper.
All right, Mr. Rich, can you state your name, please?
Kylie Rich.
And how are you employed?
I'm the Chief Deputy Probation Officer at Spalding County Sentence Enforcement.
All right, and is Miss Ariel Dorsey, is she on probation with the Spalding County Sentence Enforcement?
Yes.
Was there an incident that occurred on May 8th of 2025 where you had interaction with Miss Dorsey?
Yes.
All right, can you tell us what happened?
Yes. So the admins chatted me asking for Miss Dorsey to be seen early than our regular standard reporting hours. So they're from 1 to 6. So I stopped what I was working on so I can accommodate Miss Dorsey to see her earlier than the reporting hours. It was her first appointment for the case. And so I'm just attempting to go over the general conditions of probation, but I met with her demeanor, which was she was clearly frustrated, so her demeanor was just very aggressive and it was rude. I mean, so I was trying to assist her and be able to answer her questions at least to the best of my abilities, but I was just constantly interrupted. And then her behavior just continued to increase, and then I was getting frustrated, she was getting frustrated, so it was clear we were not going to be able to make progress that day with how frustrated she was. So I had to stop the appointment. I wasn't able to really complete it in its entirety due to her attitude and her demeanor. And she was cursing, but then she left my office, and that was the end of it. So I just made a note that we wouldn't be able to accommodate her any earlier, and then I made a note that she went into a rant just about the probation in general and the process prior to probation that unfortunately I had nothing to do with, so there wasn't anything I could assist with that situation. And then Miss Peterson heard further rude comments down the hallway that I wasn't aware of. And so that's just where we're at today with the revocation being set.
All right, so this was her first appointment,
Yes,
and she showed up early and asked to be accommodated,
yes,
which you did.
yes.
And then you said she was cussing. What specifically did she say to you?
I don't remember anything specific. But it was just a lot of curse words, not necessarily towards me, but just in general when she was talking, when we were having our interaction together.
So she was disrespectful.
I would consider it disrespectful, yes.
All right, and had you had any prior interaction with Ms. Dorsey before this?
She's been on probation before, but nothing significant.
Okay. And do you know how, does she have one case, two cases, three, do you know how long she's on probation?
She has 2 cases with us, 2 cases as of right now.
Do you know what the charge is on the person?
So the case right now is disorderly conduct. I'm not sure what her charge is for her consecutive case.
But it'd be a 24-month sentence.
It's 12 months for the case that we're currently on, and it's a consecutive case for an additional 12 months.
So yes, so. All right. Is there anything else that occurred that morning that you need to add?
No.
All right. So that's all the questions I have for Ms. Bridge.
Okay. Ms. Dorsey, you may ask, again, this is a probable cause hearing, not a full hearing, so normally you do not participate in this thing. It's just done kind of off the side, but you may ask questions if you wish on this matter before I make my decision.
Yes, sir. Question. I really want to know, why did you say that I came in to be accommodated early? I didn't ask to be accommodated early. I was called. Someone called me to tell me to come in on May 8th at 9:00 to see you the first day. My original paper said May 9th. I was called about, stated that she would call you to see if you could see me at 9 before I leave. If not, I would have to come back at 1. And so I told her, yes, ma'am. Okay. And I waited. And she came and got me. She said that you would be able to see me.
All right. To the best of your abilities, interpret that as a question and try to answer it.
Sure. I mean, I'm looking in our notes, and we do have where you spoke to Miss Rosario, but she has in here that she told you it was going to be May 8th between 1 and 5.
Yes, she told me that on the phone to come in May 8th at 9. That's why I showed up at 9. I just didn't show up just to show up.
Yeah, our documentation is not showing that, and it's not a part of our standard procedure.
Do you have any more questions?
I do want to say, I just want to know, like, when you say that
Hold on. Are you making a statement or asking a question?
I was going to ask a question.
Then you may continue.
Yes, sir. The cuss words that you said that I stated, what cuss words did I say to you?
Like I said to Mr. Shepard, I don't remember any specifics of our conversation. I just remember that your demeanor, it was very intense. So I just wasn't able to assist you and complete the appointment, so I just made that note.
Okay.
Okay. Any other questions?
No, sir.
All right. Mr. Shepard, any redirect?
No, sir, Judge.
All right. All right, you're released. You may stay or go, please. All right. Anything else, Mr. Shepard?
Yes, it's 7 calls, Savannah Peter.
All right. If you'll get Ms. Peterson to step. Oh, Ms. Peterson's right there. I have not sworn in Ms. Peterson.
Before you raise your right hand, please. Swear the testimony you're about to give before the court this morning will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, can you state your name, please?
Savannah Peterson.
Ms. Peterson, how are you employed?
I work at the Spalding County Citizen Enforcement.
All right, were you an employee there on May 8th of 2025?
Yes, sir.
Were you present when an incident occurred involving Ms. Ariel Dorsey?
Yes, sir.
Is that Ms. Dorsey seated over here?
Yes,
Defense
sir.
State? All right, is Ms. Dorsey a probation?
Yes, sir.
All right, can you tell us what you observed that morning?
The admins chatted in our group chat that Miss Dorsey was there early and asked if any one of us can see her during before reporting hours. I was going to see Miss Dorsey, but then Miss Rich decided to see Miss Dorsey. I was preparing to actually come to court, waiting to come over here. Then I overheard the report between Miss Rich and Miss Dorsey, and it didn't sound productive at all. I heard Miss Rich constantly trying to speak and Miss Dorsey speaking over Miss Rich. So that's why I stayed a little bit longer to see how the appointment will continue on. Miss Dorsey was loud. I'm not going to speak exactly verbatim what she said because I don't recall. But I know when the appointment was over, she was leaving Miss Rich's office, heading to the front, and she stated a curse word at that time.
What'd
On the
she
way
say?
there. She used the word bitch.
And you heard Ms. Dorsey say that?
Yes.
Was it directed at anyone in particular, could you tell?
Not in particular. She was just walking past and said that.
So other than Ms. Rich and yourself, was there any other staff around that would have also heard?
It would have just been me because our admin was in the front.
Is there anything else that occurred that morning that I didn't ask you about?
Not that I can think of, no, sir.
That's all the questions I have for Ms. Peterson.
All right. Ms. Dorsey, you may ask any questions you have of Ms. Peterson.
I don't have any questions.
Okay. Part of the allegations, and this is an awkward part of what we do, but part of the allegations seems to indicate that there was a comment made about Ms. Rich's physical appearance. Is that correct? Or is that something else? Or am I mixing that up with somebody else?
Not in regards to her physical appearance. I don't believe so, no, sir.
Okay. All right. Anything else?
No, sir, Judge, we don't have any further witnesses.
Okay. All right, thank you very much. All right, Ms. Dorsey, again, this is a probable cause hearing. Do you have anything you wish to testify to? You do not have to testify. You have the absolute right to remain silent. And anything you say here will be taken down and transcribed and may be used against you. But if you do wish to make a statement, you certainly can. Do you wish to make a statement?
Can I ask a question first?
You may.
When you say make a statement, can I say what happened? Like, can I tell my story or?
You certainly can. If you do, Mr. Shepard will ask you questions. You'll be required to answer those questions. And I'm just making certain you hear me say that you don't have to, and if you choose not to, there's no scenario where I will hold that against you. Does that make sense?
Yes, sir.
Okay. But yes, if you want to make a statement, I'll have you just sit right there, use the microphone, make a statement, but just know that Mr. Shepard's going to ask you questions, and you'll have to answer those questions.
Okay.
Do you want to make a statement, or do you want to remain silent?
I just want to remain silent.
Okay. All right. Well, then, do you have any other witnesses you wish to call?
No, nobody was in the office but us.
Okay. All right. Mr. Shepard, anything else?
Judge, I mean, nobody wants to be on probation, and nobody's happy about it, but the folks that work in sentence enforcement don't deserve that. They deserve to have people there to be respected. They're just trying to do their job just like the rest of us. For somebody to come in and be cussing at them, be rude, be disruptive, they just don't deserve that. And I just don't think it should be allowed to happen. I think there needs to be consequences for those kind of actions.
Okay. All right. Ms. Dorsey, anything else you want me to know? Anything else you want to tell me? Now, this is called closing argument. So what you say at this point is not evidence. You won't be questioned about it.
Judge
But if you
Decker.
want to fill me in a little bit on what you think should happen next, I'd love to hear it.
Yes, sir. Your Honor, I honestly did not cuss Miss Rich out. I didn't even say the B word leaving her office. If they can approve that, I would love for them to prove this. But I did not go in there with a nasty demeanor at Miss Rich. I just went in there and I was asking questions because I do not know the law. So I just wanted to know, like, what are my options? Because I do not have a job. And she was saying that I had to come and pay like $119 a month. And I was just telling her, well, since I'm on probation now, my background is on my record and it's just telling me the type of job that I do healthcare. And so it was just knocking me out because it's probation. So I was like, right now, I can't get a job. So how do I pay my probation without a job? Can I do community service? These are the questions I asked her. She gave me the floor to speak. I didn't overtalk her. I did not. Actually, she was the snappy one. She's the one that had the attitude with me. Because she was like, well, you took the plea deal, right? And I was like, yes, ma'am, I did. And so she was like, well, your problems are personal problems. And I get that. So I was just thinking I could go and talk to her about it, and I see that I couldn't. I see that I can't now. So I did not, no, sir, I did not cuss. I did not call her the B word. And Miss Peterson, she was not even in the office with us. It was just me and Miss Rich. Again, I did not go to the probation office just to be accommodated at 9 o'clock on my own. I was told this over the phone. My regular appointment to be there was May 9th. This is what I got on my paperwork when I came to court on April 16th. They told me to come here to talk to her on May 9th, to Miss Lawson. That was on my paper on May 9th. I got a call. My grandma called. She said somebody called from the Spalding County court or whatever. So I called the number back. It was the probation office, and they told me to come in at May 8th at 9 o'clock. And that's what I did. I came with May 8th and a money order. I did not. I promise I did not go there with a bad attitude because I know what I'm facing. I know I can go to jail, and I don't want to go to jail. This is not what I wanted to do.
Okay.
You know, and this charge happened in 2022. That's what I was telling Ms. Rich. I said this happened in 2022, so I was a little bit confused because it's 2025.
Right.
And so I was just explaining that to her. It wasn't nothing personal. I wasn't being rude, and I did not cuss at her or when I left the office. I just want to say that.
All right. Anything else you want me to know?
No, sir.
Okay. All right. So the evidence is now closed. The evidence, as I have heard it, is that Miss Dorsey reported at 9 a.m. on May 8th, had an original date of May 9th to report to the Sentence Enforcement Office, and that the Sentence Enforcement team accommodated that early report. And I just want to say out loud, Ms. Dorsey, you're not in trouble for reporting early. I understand you're saying there's confusion, but that's not the issue. The issue is that when the department was created, we all made an agreement that if one department member can hear a conversation in the next office because of the way that's built, that means that that is a heated, loud conversation. Those conversations do not carry across. And so Director Matthews and I had spoken about that previously, not with your case specifically, but just generally, that if there is something loud enough being said in one room that carries over to another, then that is the disruption of the office by default, in my opinion. I'm also looking at the back of your sentence sheet. It says here on paragraph C, subsection 4, that you are to interact respectfully with all court personnel. You're to interact courteously and respectfully with all court personnel, answer all questions truthfully, accurately, and completely, sign all requested administrative documents when requested. What I heard today was Deputy Director Rich saying that despite having made an exception to meet with you that morning, that due to your demeanor, she was unable to complete that, which means that was a waste of time. And then Ms. Peterson also had to stop what she was doing because she could hear what was going on, which means that the voices were raised. She did not hear it. I know you're saying you didn't say the word bitch, but frankly, I heard Ms. Peterson say that she did. And so I guess I'm left with that either you were acting appropriately and the entire team was acting incorrectly, or frankly, the more likely option here that I'm looking at is that your statement that you were still confused as to why this was 2 years later tells me the state of that interaction. And let's not forget that before we even got started, I asked you multiple very direct questions, and to the point where I got frustrated because you gave me vague and indirect answers. So like even here in the courtroom under oath, I couldn't get a straight answer to you until I stopped what I was doing, looked you in the eye, told you I was frustrated, and then they were there. I cannot imagine your demeanor not in a courtroom with deputies all around you. I just can't imagine it. And so the short answer for me is that I find there is sufficient probable cause for you to be taken into custody. I do believe an arrest warrant is proper. I don't believe you should be allowed to interrupt the orderly operations of the Sentence Enforcement Office. You can take her into custody. All right, so I strongly suggest you not make a noise out in the gallery, because then I'll have to deal with that as well. You will be given opportunity to speak with her in just a minute, and somebody will be able to see you in the jail. All right. Please give her a reset notice for whatever our next, what was it, Nick? Do what? Do what? June 4th. Okay. So whatever y'all pick. Okay. And then obviously Piper, if you'll talk to the mom and see if she's passed anything off. I assume that's the mom. So think we had a date earlier. Yeah, today was just a probable cause hearing. So the only decision I made today was whether or not she was to be taken into custody.
Okay.
She's taken into custody, now she'll be in Virgil Brown's office, and you have full scale hearing.
Okay. Thank you.
Judge, I've been texting with Brent about it.
Yeah, perfect. So if you'll let her know that we reached out to Virgil Brown's office to help facilitate. Mr. Shepherd, thank you for your assistance in that. Sure. Okay. We still need fully put it to the. Okay. Mr. Shepherd, while they're sorting that out, what else are you here on?
So Judge, you got several pleas that were pretrial diversions that are going to be pleas now in underlying cases.
Okay.
Mr. Cone, Mr. Keith, and Mr. Watson.
Okay. We're just getting organized.
Those should be signed up, ready to go pleas.
Okay.
I believe we're going to have a hearing, well, I know we're going to have a hearing on Mr. Rice with Mr. Barton. I'm not 100% certain on Mr. Pittman. I definitely want to be heard on that. I don't know, I don't think it's going to reach the level of a full-scale hearing this morning.
Okay.
And then there was one more, Collier. Ms. Matthews had asked me to take a look at that one.
Okay.
So I guess to answer your question, everything else on the calendar.
All right, so I just thought that. So can I go ahead and do these pleas while they're getting her sorted out? All right, well then let's have, let's go ahead and do these pleas. I've got 3. Let's have Watson come up to the podium. And I would like Cone to come up to the defense table in this first seat. And I would like Keith to come up to the table and have a seat in the second seat. So Watson, Keith, and Cone, y'all come on up, grab your seats, that's directed.
Before we start taking these pleas, all of these were pretrial diversions. I believe Ms. Matthews may have to fill in some of that, but all of them have probably paid something. You know, we run into that issue with, so I set fine amounts on all of them, that's normal. So I'm just making the court aware there's going to be that issue.
Okay, thank you for that. All right, Mr. Watson, correct?
Yes, sir.
Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down and state your full name for me.
Amante Tyron Lee West.
Mr. Watson, you are here today on 22 SR 2423. Am I correct that you were participating in our pretrial diversion program
Yes, sir.
and that program did not work out for you as we all had hoped? Is that correct?
Yes, sir.
And that we're removing you from that program and you're entering this plea?
Yes, sir.
Now, during the program, did you pay any monies into the court? Or do you know if you paid any monies into the court? I only ask because our computer system, and I'll have the same question for you too, our computer system, not our system itself of us, has a really difficult time converting a fees paid on a pretrial into monies on a case. And so I just need to know if that's an issue that I need to worry about. Okay. All right. Well, then I'm going to leave it be. And if it turns out it's the case, then what I'm going to do is I'm just going to issue an order without coming back to you that converts your fine into community service work. Do you understand that if that's an issue, that's the step I will take without another hearing?
Yes, sir.
Is that acceptable?
Yes, sir.
All right. Well, then we're good to go. All right. Mr. Watson, you have passed up this self-represented defendant plea rights waiver. Is that correct?
Yes, sir.
Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
Did you understand everything that's on it?
Yes, sir.
Mr. Watson, are there any questions that I can answer for you about anything anywhere on this document?
No, sir.
Did you see on here where it says you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do? Do
Yes, sir.
you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
All right, Mr. Watson, you are charged with one count of theft by taking, and that you did.
I don't have an accusation.
That's all right.
I'm sorry.
I've got it right here. I just need about 30 seconds to pull it up.
I could do this. I ain't even did it.
Incident date 7/18/21.
Got it.
Sir.
There we go. All right, so it's one count of theft by taking, and that you did commit the offense of theft by taking food, the property of McDonald's on 7/18/21 here in Spalding County. Did you do that?
No, I didn't.
Okay. Do you want to go forward with this plea as what's called a best interest plea? A best interest plea is where you deny the actual facts, but instead you pivot and you say to me that you wish to enter this plea because you wish to accept these terms, not because you wish to accept that you wish to admit to the underlying facts. That's called a best interest plea.
Okay.
Would you like to move forward with this plea as a best interest plea? Or would you like me to pivot and address bond on your case now that you're out of the pretrial diversion program?
Plea.
Okay. Then I'm going to move this forward with your permission as a best interest plea. Is that correct?
Yes, sir.
All right. So I'm going to take away the question of did you do it? And I'm going to pivot to Mr. Watson, with this theft by taking with food from McDonald's on July 18th of 2021, do you wish to enter a guilty plea on this? Not because you're admitting to the underlying facts, but because you think that this plea is what's in your best interest.
Yes, sir.
Okay. And then count two is that you also had disorderly conduct during the same course of events. Do you wish to enter a best interest plea to that disorderly conduct charge as well?
Yes, sir.
Okay, I'm going to find that your request for a best interest plea is proper, and I'm going to grant it. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. Reviewed the recommendation, and I'll follow it. Any questions before I sentence?
No, sir. But
Okay.
I know for a fact, though, I ain't steal nothing, though. That's all I want to say.
Okay, well, we don't have to do this plea. We can certainly stop doing this plea, and I can pivot. I have other options I can explore. So if you want to enter the plea, great. If you don't want to enter the plea, great. I don't have a preference here. I just need you. We just almost finished this plea, so like, if you
All right,
didn't want
you
to
go
take the
ahead,
plea, you shouldn't take the plea.
Go ahead and take the plea.
Okay, because you've now said twice you don't want to take the plea, and I'm at this point kind of hesitant to take it. So, so I'm going to ask you one more time, and I need you to be decisive. Decisive. Do you understand? I'm not telling you what to do. I'm telling you to just be decisive about what you think is best for your case. Do you want me to take this plea, or do you want me to pivot to a bond hearing on your case?
Yeah, you can take the plea.
Okay, then I'm going to take you at your word that that is what you want me to do. All right. Any questions before I sentence?
No, sir.
All right. Count one, theft by taking. The best interest plea is granted. It's guilty. 12 months, $590 is your fine. Count two, disorderly conduct. It's guilty. 12 months, $0 is your fine. You may work your fine off with community service work. No alcohol, illegal drugs, or hemp products. You'll be screened for those, and you'll waive any foundations for admissibility. $60 per month supervision fee, $50 intake fee. This case will close the moment you've satisfied your obligations to the court, which include 20 hours of community service work. As I have removed you from the pretrial diversion program, if you paid any monies and were unable to work that out due to our issues with the sentence, with the software, then I will automatically file an order converting all fines into community service work, but we'll cross that bridge when we get to it. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you have any questions for me about anything before you and I part ways?
No, sir.
All right. The bailiffs are going to take your paperwork. They're going to have you sign it, including the paperwork where you agree to be removed from the pretrial diversion program. I must put that one on the top here. And good luck to you, sir. All right. If you'll take him out to meet with Ms. Peterson. All right. Next case is Cone.
She's already met with him.
Okay.
I'll-
Sorry about that.
That's okay.
All right, Mr. Cohn, raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down. Will you please state your full name for me?
Tabiante Cone.
All right, and Mr. Cohn, you are here today on 23 SR 1896, and it's my understanding that you are consenting to being removed from our pretrial diversion program and are entering this plea to close your case. Is that correct?
Yes, sir, that's correct.
All right, Mr. Cohn, you have passed up to me the self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir, I do.
Do you recognize your initials next to each of the lines here on page 1,
Yes, sir, I do.
page 2,
Yes, sir, I do.
and is that your signature?
Yes, sir.
Mr. Cohn, do you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And did you understand everything that's on it?
Yes, sir, I do.
Are there any questions I can answer for you about anything anywhere on this document, no matter how minor?
No, sir, but I want to ask you a question. I don't have a job or I don't get disability for my hearing aid, so I was trying to see, can I do everything in community service?
Mostly, yes. We have all kinds of options. So you're going to find that what you need has a pathway to fit what you need.
Okay.
So I don't worry about that at all. I'm not going to go into the details with you, but the answer is there's going to be a pathway that's going to work for you on that situation.
Okay.
That's a good question, though. Any other questions?
No, sir, that's
Okay.
it.
Mr. Cohn, you did you see on here that you have the right to have an attorney represent you?
Yes, sir, I did.
And you're here representing yourself. Is that what you want to do? Do
Yes, sir.
you understand that you have the right to a jury trial on your case?
Yes, sir.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir, I do.
All right. And just say it out loud. You're consenting to me removing you from the pretrial diversion program. Is that correct?
Yes, sir.
All right. Now, did you commit the offense of possession of a drug-related object on 2/19/23 here in Spalding County by illegally possessing an item that is used as drug paraphernalia? Did you?
Yes,
do
sir.
that? All right. I find with your admission of guilt, there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I'll follow it. Any questions for me about anything before I sentence?
No, sir.
Okay. Mr. Cohn, as to 23 SR 1896, count 1, possession of a drug-related objects, guilty. It's 12 months. 590 is your fine. Again, you'll talk to them about getting that converted. You may work your fine off with community service work. No alcohol, illegal drugs, or hemp products. You'll be tested for those. And you'll waive any foundations for admissibility. $60 per month supervision fee, $50 intake fee. This case will close the moment you've satisfied your obligations to the court,
Okay.
which include 20 hours of community service work. So you have the key to closure in your hands, okay? You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Can I answer any questions for you about anything?
No, sir, that'll be all.
All right. I just have the bills. Okay, all right, you can walk him back. Thank you. All right, sir, you can come on up. Keith? Dwayne? Can we find the attorney one instead of the self-represented? I'm gonna start with this. If you'll go find the self-represented and we'll just pivot over afterwards. Okay. Mr. Keith, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Patrick Kendall Eugene Keith.
Okay. Mr. Keith, you have signed, this one says attorney and defendant, which means we accidentally gave you the wrong form. But the majority of what's on here applies to what we're about to talk about. So do you recognize this document?
Yes, sir.
And you don't have an attorney, is that correct?
Yes, sir.
All right, so the only thing that's different on here from the one that Mr. Williams has in his hand that we'll get you to fill out in just a minute is the part about having an attorney. All right, so do you understand you have the right to have an attorney
Yes, sir.
and that you're here representing yourself? Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that's on the document here, correct?
Yes, sir.
And by entering this plea, you're waiving the right to a trial. Is that what you want to do? Do you want to close this case today with the plea?
Yes, sir.
Got it. Okay. Now, in just a little bit, when we're finished, we're going to swap this document out with the other one. The only difference being that you have, it'll say that you're waiving the right to have an attorney.
Yes, sir.
Okay. Now, did you commit the offense of possession of a drug-related object here in Spalding County on January 15th of 2024 by possessing drug paraphernalia?
Yes, sir.
I find that with your admission of guilt, there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation, and I'll follow it. Any questions before I sentence?
Yes, sir. About the fines, what money I paid for the other.
You
when I was
paid money
on
into the other?
Yes, sir.
Okay, we will sort that out. Thank you for letting us know.
Yes,
We
sir.
will sort that out once we get in. If that's the case, we'll convert your fine to community service work.
Never mind. Act like I didn't say nothing.
So, well, no, I'm just saying that happens automatically. Like that's not,
okay.
that's not a conversation we have. It's something I need to make certain you're aware of, that it's a software issue
Yes,
in
sir.
our system that we have, despite 4 or 5 years of trying to fix, haven't been able to fix.
All right.
So the software,
Paid $30 towards the court fine.
is that going to miss? Oh, okay. Looks
I
like we,
think I figured out a workaround.
awesome. Great job. Okay. They said they fixed it.
All right.
So, all right, then, you ready for me to sentence?
Yes, sir.
All right, possession of drug-related objects, guilty, 12 months, 590 is your fine. All other charges are dismissed. No alcohol, illegal drugs, or hemp products shall be tested for those. Fourth Amendment waiver, $60 per month supervision fee, $50 intake fee. This case will close the moment you've satisfied your obligations to the court, which include 20 hours of community service work. Additionally, I have the attorney and defendant plea rights waiver that you've initialed, but we're going to swap that out for the correct one in just a minute. And then you're going to also sign this document here, which is what allows you, which is you consenting to being removed from our pretrial diversion program.
All right.
Do you have any questions for me about anything before we part ways?
No, sir.
All right, Clint, if you will walk him out, have him fill out the other form, we're good to go. All right, that's my 3 pleas. At this point, everyone, I'm handing the calendar over to Director Matthews. And I'm going to stop calling the cases in the order, whatever order Director Matthews with Mr. Shepherd call next. We'll do that from now to the end of the calendar. So no hurry, but whenever you're ready, you can call whatever is next.
Erica Collier.
All right. Good morning, Ms. Collier.
Hey, good morning.
If you'll please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You can take your hand down, state your full name for me.
Erica Shante Collier.
All right. Ms. Collier, you, here we are. You are here today on 22 SR 2366. According to the documents in front of me, you're here today because you're on probation with our office and your sentence enforcement supervisor has filed paperwork alleging that you were out of compliance with your probation. Do you understand what you're doing here today?
Yes.
You understand that you have the right to have an attorney represent you?
Yes.
And you're here representing yourself?
Yes.
Is that what you want to do?
Yes.
You have a recommendation?
I do.
Okay, so what's going to happen next is Director Matthews is about to read out 2 sets of information for you. And this will very likely be similar to everybody else out there. She's going to read out what the allegations are of how you may or may not be out of compliance.
Right.
Then she's also going to read out what the state's recommendation is to the court on how to respond to that.
Okay.
So, and then I'll ask you 2 questions. Do you admit to the violations, yes or no?
Right.
And is that recommendation acceptable, yes or no?
Right.
If you say yes and yes, I'll very likely make that the order of the court. If you say no, we'll sort it out. Okay?
Okay.
You ready?
Yes.
Floor's yours.
Judge, on 22 SR 2366, the defendant is alleged to have violated the terms and condition of probation in the following. The defendant failed to report to probation as directed, having missed 3 of 9 scheduled appointments. The defendants failed to pay the court fine and fees as ordered or utilize community service work in lieu of the court fine, being in arrears $1,099. The defendant failed to submit to an alcohol or drug screening test as requested by probation. Judge, this case has had an active warrant since January the 16th of 2025 by your signature. Probation requests to revoke 75 days and terminate the balance.
Okay, so Ms. Collier, the recommendation, so do you admit to the violations? We'll start there.
Yes, I do.
All right, and then the recommendation on your case is to revoke a specific amount of time, which is 75 days to the jail, and then be done. So no, when you get out, there'll be no probation after that. Is that recommendation acceptable to you?
No.
Okay. What is it that you think the court should do in response to these violations?
Can I make a statement?
Sure.
Okay, so I just recently had a baby, as I told the officer that I had, and I had a C-section, so I was prescribed opioids, and I couldn't walk because I didn't have a car at the time to go to, take the drug test and do what I need to do. So, but I have everything in order now. So,
Okay. How old's your baby?
6 months. I had him November 10th.
All right. Congratulations.
Thank you.
Okay, well, either way, I need to get this case closed. So I didn't, it wasn't lost on me that there was a warrant out for, what was that date again?
January 16th of 2025. I don't have an officer on this caseload, and so it kind of fell through the cracks until I came across it.
Sure.
So that's why I set this court date, Judge.
Okay. Yeah, so there was a warrant out for a bit here. Where were you when the warrant was looking for you? What was going on there?
At home, I didn't even know
Okay.
because I was communicating through email. I don't know if you guys can see it, but I was communicating with them to let them know everything.
Judge, she allegedly lives in Texas, and that's why it's been difficult to hold this warrant because she was on phone reports. So
Got it.
again, that's why the revocation was set today. I don't have an updated address that she's anywhere other than Texas.
Okay. Where do you live?
And the address that's on file, 110 Kennedy,
You don't live in
Texas.
You don't live in Texas? Oh, you live in Texas?
Yeah,
or
I live in
don't?
Texas.
Okay.
I was saying the address, sorry.
Okay, that's fine. All right, then, did you offer a consent on this one?
No, sir, Judge. Again, I didn't. We haven't been in communication with Ms. Collier since about March. And so I set this court date again, anticipating that it would just be a tolling in reference to the matters due to her living in Texas.
Yeah.
The court's position on anyone who fails to submit to a random drug screen is just the remainder of their case in jail. Therefore, we didn't offer Ms. Collier a resolve due to that's the court's typical directions in these matters.
I agree with that, and that is an accurate statement of my policy, so, okay. Ms. Collier, so you've admitted the violation, so what we're trying to figure out is what's my response going to be? Do you understand where we're at procedurally?
Yes.
And Director Matthews just made a statement you really needed to hear, which is that my typical response to a case in this situation, which has nothing to do with you, Ms. Collier, is to say, hey, look, if you've got this level of items going on, really it's to just revoke the balance and close it. So I'm just letting you know that Director Matthews is correct in what she just said, that
Right.
75 days is my standard response, not because 75 days is special, but because that's what you have left.
Right.
Okay, go ahead.
I was just wondering if it's any way I can move the case so it can be kind of easier to Texas. If there's any way. I don't
Say
know.
that one more time.
If there's any way that you guys can move the case to Texas so I can be able to do everything, without it having to be so hard.
Well, we had you on online reporting, which is the closest we can get to moving it to Texas. I don't have a pathway to get it to Texas, but that did not work.
Right.
Which I think we're all in agreement that did not work. So, okay. Well, I'll tell you what. You admitted to the violation, and it is my policy to do that. But what I am going to do is, because you've admitted, I do want to acknowledge that you you came over from Texas,
Yes.
stood in front of me and took some responsibility for it. We're
Yes.
just trying to decide what to do. So I am going to order the difference to the jail, but I'm not taking her into custody right here. So y'all can take it easy, because I'm going to reward you with that, to say you stood here in the belly of the beast, took responsibility for it. So how much time do you need to get yourself turned into the jail to get us finished with this?
I was planning on moving back when my lease is up. I don't know how much time you guys gonna give me, but I was planning to move back in August.
August to
Yes.
Texas.
Yeah, from Texas back to Georgia. Yes.
I still think you're going to be all right with that. I'm going to give you till this is Memorial Day, till next Friday to turn yourself in. Next Friday being 24th? Okay. 30th? Okay, so you're gonna turn yourself in on the 30th. You will report to sentence enforcement that Friday.
Okay.
And then after that, you will go check in at the jail, and then that'll be it for us.
Okay.
Now, how much of that you do is up to the sheriff. I have no say in that whatsoever.
Okay.
All right, Ms. Collier, any questions for me?
Nope.
Okay, you're gonna need to sign this. You'll check in next Friday. Then you'll go to the jail. Once we confirm, I gotta get this one. Once we confirm that you're in the jail, we'll close your case.
Okay. Thank you.
All right, so if you'll just stand out there, wait for the bailiffs.
Patrick, do you want to do Rice?
Can
Stephen Rice.
Morning, Judge. Mr. Barton, it's always good to have you here.
Good to be here.
All right, so, all right, Mr. Rice, if you'll have a seat right there, you don't need to raise your right hand or anything, but I'm going to place you under oath. Are you ready? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. All right, Mr. Barton, tell me what we're about to do from y'all's perspective.
Sure, Judge. What we've got here is Mr. Rice came in with me 6 or 8 months ago. I think it was in November, and we did a plea on 2 cases at one time. One was a reckless, one was a DUI. It was some other charges as well. It's a total, I believe, of 4 years of probation. And he's done very well on that probation. Matter of fact, he's done perfectly well on that probation. Except he's going through a very emotional breakup with his girlfriend and the mother of his child. And it got ugly, Judge, very, very emotional. So that's resulted in 2 new charges that we're dealing with here today. One is a harassing phone calls charge for some harassing phone calls. And the other one is a violation of a TPO. The ex-girlfriend got a TPO. It was served on my client, and he violated it and admitted violating it. So we've already worked out a plea agreement on the new charges, Judge. On the harassing phone calls, we're going to plead guilty to that, straight up, 12 months probation, a fine, and maybe anger management class or something.
And stay away from.
And stay away.
Stay away from the
And stay away. And then on the TPO charge, Judge, we're going to tender a guilty plea to the court on that under very similar circumstances, similar terms. Only we'd like to do that one under the First Offender Act, Judge. We'd like to preserve his first offender on that one if we can. I don't think there's an
I believe he
objection.
qualifies, Judge, so
Right.
the court's inclined to
Right.
accept it. He does.
So we're taking responsibility, Judge, 100% responsibility for the immature emotional behavior that led to some ugly phone calls and social media posts. And he's pleaded guilty to that, Judge.
Okay.
What's left for the court to decide is, although he did his probation perfectly well on the DUIs as far as DUI stuff, he did commit a new offense while on probation, which is a violation. Even though he didn't do anything, I guess it's a little bit like when you tell a kid, hey, don't run in the house, and then the kid runs in the house and does the same thing again. Well, that makes you pretty mad. In this case, that's not what happened. He did something that's completely unrelated, but, very immature. And it's the social media thing now. People say things on social media they shouldn't say. And it's hard to understand. Mr. Shepard and I were talking about that today. But what you've got to decide is basically on his revocation of his probation, which they filed a petition, and we're admitting the violation. And the petition says that he violated his probation by committing these 2 new offenses, and we're pleading guilty to those offenses, and we're admitting and stipulating that happened. I've seen the evidence. The solicitor's office very hurriedly got me all of that information, so I've had a chance to review the discovery and go over it with my client. We've executed a waiver of rights form on both cases, and we're tendering a plea. The question is, how much time in jail should Mr. Rice get for committing the offense of harassing phone calls and TPO violation with his girlfriend and mother of his child? Judge, that's the issue for the court today.
Okay.
All right? Everything else is pretty much agreed to. So it's not quite as big and bad as it looked, maybe.
Well, it could have been, but I appreciate what y'all could work out. So, sir, if you'll come up to the podium with your attorney and just get lined up with the microphone there. Sure.
You want to plea and then hear on the.
That's what I thought, is I'd go ahead and lock the first part down.
Right.
And then do the hearing on the other one, because in my mind, they're separate, they're orderly steps I got to take in that order. So, all right, Mr. Rice, I've already placed you under oath. State your full name for me.
Stephen Christopher Rice.
Okay. Mr. Rice, you have 4 cases in front of me today. We have the 2 probation matters, which are 23 SR 812 and 24 SR 1097. What we're about to do is enter pleas on 2 additional cases, which are 25 SR 660, which is a family violence order violation, and 25 SR 0471, which is a harassing phone calls case. Is that your understanding of what we're about to do?
Yes, Your Honor.
After those pleas, I will then make a decision as to what the court should do based off of the pleas, which would be the violations to the original charges.
Yes, Your Honor.
Did I get that right?
Yes, Judge.
Okay. Mr. Rice, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, Your Honor.
Are these your initials next to each of the lines on page 1,
Yes, Your Honor.
page 2?
Yes, Your Honor.
And is that your signature?
Yes, Your Honor.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, Your Honor.
And did you understand, did you have a chance to ask Mr. Barton any questions that you had?
Yes, Your Honor.
And did you understand everything that's on it?
Yes, Your Honor.
Any questions I can answer for you about anything anywhere on this document?
No, sir.
Mr. Barton, as I didn't do my standard rights review, but when I started court, I'll just ask you, did you review this document fully with your client?
I did, Judge. I've explained to him all of his statutory and constitutional rights, and I believe he understood it, and I believe he's confident in the plea this morning.
Perfect. And Mr. Rice, have you had all the time you need to speak with your attorney about all aspects of your cases?
Yes, Your Honor.
Are you satisfied with the job your attorney's done on your behalf?
Yes, Your Honor.
Do you understand that you have the right to a jury trial on each of your 2 cases?
Yes. Yes, Your
And
Honor.
that by entering these pleas, there will be no trials. These cases will be closed. Is that what you want to do?
Yes, Your Honor.
And you understand by entering these pleas, it will trigger me making a decision as to what the court should do on these other cases.
Yes, Your Honor.
Okay. Now, Mr. Barton, do you stipulate, you're a first offender. Have you used a first offender on anything in the last, have you used a first offender on anything ever?
No, Your Honor.
All right. Are you convicted felon?
No, Your Honor.
And have you been convicted of any family violence charges previously?
No, Your Honor.
All right, then you qualify for first offender. The way first offender works is you will be granted this. It is a tentative grant. So you must go and you must complete this first case because it only goes through this first case of ours. So it's from the beginning of 25 SR 660 and followed and then ending when 25 SR 660 ends. So you complete that without any issue and you will get to keep your first offender and you will not have a conviction for violation of a family violence order. Do you understand that?
Yes, Your Honor.
And then if you don't do it, we'll have a hearing very similar to this where you stand there and I sit here and then I will decide whether to take that privilege away from you. You don't get a jury trial, you just get a hearing. And if I take it, then you've lost it and you're convicted and you'll never get it again. Do you understand that?
Yes, Your Honor.
Okay, I feel like we've covered that
Yeah,
well.
Judge, just for the record, I've explained to him the good side and the bad side of first offender and the mechanics of how it works.
Excellent.
He understands.
Perfect. Mr. Rice, any other questions before I pivot to your attorney?
No, Your Honor.
All right, Mr. Barton, for the purpose of this first offender plea, do you stipulate that there's a factual basis for me to accept this violation of a family violence order?
Yes, Judge, the state very rapidly provided me with all the discovery and service notice and all that, so we had a chance to review all that, and I've had a chance to go over it with my client, so we would so stipulate.
Okay. All right, then violation, and Mr. Rice, do you wish to enter a guilty plea under the first offender to this violation of a family violence order charge?
Yes, Your Honor.
All right, Mr. Barton, pivoting to the second case, 25 SR 471, do you stipulate that there's factual basis to support this harassing phone calls charge from 3/7/25 here in Spalding County?
Yes, Judge, and same thing, that the state very rapidly got all that for me. We asked for it, we got it, we appreciate that.
All right, perfect. And then, Mr. Rice, do you wish to enter a guilty plea to that harassing phone calls charge?
Yes, Your Honor.
All right, Mr. Rice, I'm going to find that with your admission of guilt on both of your cases, combined with your attorney's stipulation as the factual basis, that there's enough for me to accept both of these pleas. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering these pleas. I reviewed the recommendation, and I'll follow it. Mr. Barton, anything on these pleas before I sentence?
Judge, if you're going to accept the recommendation, then we'll just leave it at that, and then I've got some letters and things about him on the, we'll save that for the revocation argument.
Oh, perfect. Okay, then I agree. We're going to do this in two phases. So, Mr. Rice, any questions before I sentence?
No, Your Honor.
All right, this is only on the two cases you've just entered the plea on. Stephen Rice on 25 SR 660, count one, violation of a family violence order, guilty, 12 months, 590 is your fine. You may work your fine off with community service work. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $60 per month supervision fee, $50 intake fee. This is consecutive to 24 SR 1097, which is the case you're already on probation for. You are to have no contact whatsoever with Kristen Wood, and that closes out 25 SR 660. Any questions so far?
No, Your Honor.
All right, moving on to 25 SR 471. On this case, harassing phone calls, guilty, 12 months, 590 is your fine. All the other conditions are the same. This is consecutive to 25 SR 660, which means we've added an additional 24 months of probation to your case. To your cases, excuse me. Do you understand that?
Yes, Your Honor.
You have 30 days from today if you wish to appeal these decisions. You have, 12 months from today if you wish to use your habeas rights on any of these decisions. All right, do we need to put anything else on the record regarding the pleas on the two cases before we pivot to the probation matters?
No, Judge.
I have a statement.
Go ahead.
So the case that y'all ran it consecutive to is the first case that he's currently on, and he has another case after that one. Is that the way the court intended for it to run?
There's two-year cases, but one runs consecutive to the other. So it's a DUI and a reckless, or a reckless and a DUI. And they are a total of 4 years. We just pled to two more cases.
Did I get it backwards on the?
I'm just trying to figure,
The
you
intention
ran
is
it to consecutive to the
currently
first
on.
one.
Let's go off record, Kathy, while we sort this out.
The two cases he's currently on that he's getting revoked on, we're about to decide on that. When those two end, these two pick up. So if I wrote the wrong case numbers in there, the intention is,
Can I just hand it to you then?
yeah.
This is why you're here. This is why she's here. So
I'm glad.
keep me out of the ditch.
Yeah, I think I probably just wrote the wrong case numbers in the wrong spot.
Cody?
My brother, all about that.
All right, let's go back on record, Kathy. All right, so what we're at now is the new, so 25 SR 471. Okay, so the order of events now is he has 23 SR 0812. And then 25 SR 660 is consecutive to 23 SR 0812 now. And then the other one has not changed. So 25 SR 471 is consecutive to 25 SR 660. So, all right, that makes sense to me. Okay,
I stapled them in the wrong order, and that's why that's what happened.
it's all right.
Thank you, Marty.
You're welcome.
Okay, so let's figure out what we're going to do with these revocation matters. So on 24 SR 1097, I show 546 days remaining.
That's correct.
On 23 SR 812, I don't know what I have left on that one.
728,
728. So I have a lot of time left.
1274 total.
Okay, is there a recommendation from the state?
Balance.
Balance, okay. All right, Mr. Barton, what are you requesting from me?
Yes, Judge. Judge, my client is otherwise first offender on this. He was sentenced under both DUI, or one DUI, one reckless case back in November. Judge, there were a number of terms and conditions that were imposed there. He's successfully complied with everything on his probation. He's been the ideal probationer. But a few months after he went on probation, he is in the middle of a very, very emotional breakup with his, almost like a divorce, Judge. Very bitter, very contested. This is not a divorce case, and we're not arguing a divorce case in here today. That might happen later on somewhere. But, you know, everybody's doing mean and nasty things to each other. And of course, with the modern way and the more younger folks, they do a lot of this on social media. So that's how we ended up with the harassing phone calls. There were some ugly things that were said on social media. Judge, so, you know, who said what to when, who, we're not getting into all that. The point is, I believe that if we tried this case in front of a jury, there'd be enough evidence of harassing phone calls that a jury could convict him of that. And the TPO was pretty black and white. He admitted to it. Even on social media, he admitted to violating the TPO. So he's taken full responsibility, Judge, for what he did wrong here. And he's now been sentenced for that. He's been sentenced for the 2 acts that were illegal that he committed. He's otherwise complied with probation and done everything correctly. But he's on probation, he committed a new offense. Judge, again, it's like when you tell someone to don't do something and they do it again. That's, you know, if he committed another driving offense, he tested positive, he failed to do his classes, then I think the court would consider revoking the balance of his time. I could see that. You told him once, we're not going to tell him twice. Judge, this case is just a very emotional, my client may be very emotionally immature in this case and didn't handle it well. And probably needs some counseling on relationship counseling on how to handle what is essentially a divorce with a child involved and all the emotions that go with that. He did not violate his DUI probation by, you know, a DUI related offense. This is separate and apart. Judge, on the harassing phone calls, again, it was not technically, it was harassing communication, which is under the same code section. It wasn't actually a phone call. There were a bunch of phone calls, but that was a different issue. So, Judge, he's employed. I've got some recommendation letters here, Judge, if I may approach. I'll show these to the state already.
I don't have anything.
Attesting to his good character. Judge, he's a hard worker. He has 2 children that he has to support. The child with the lady involved in this case, and then one other previous relationship child. And the longer he stays in jail, Judge, his child support bills just getting higher and higher, and the children are going without support. He's a very intelligent guy, Judge. He's a very pleasant guy with some counseling from a good psychologist or a relationship type counselor on how to handle the stress and the emotion of this, breakup. He's very much in love with this person, and breaking up with has been very difficult. And you can hear and feel the emotion in the text and the post, and it's raw, Judge. So it was emotion and not intent. And so we would ask. He's been in jail now about 40 some odd days, I want to say. Judge, it's gotten his attention. He will do very well on probation with you, as he has already, and he will benefit from the ordered evaluation and counseling with this very, very difficult personal situation.
Okay,
Judge, he's taking responsibility.
I've caught
That's all I
that.
got, Judge.
Director Matthews, the order of cases are 24 SR 1097 is the first case?
Yes, sir.
And on the first case, I have 546 remaining.
Correct.
And on the second case, 23 SR 812, I have 728 remaining.
Correct. Yes, sir.
Okay.
It's not, that one's not running.
Not running at all. We're still waiting.
That's right.
All right. I just want to make certain I had the procedural aspect correct. All right, Mr. Shepherd, do you want to, anything else?
For me?
I just said, do you have anything else?
Oh, yes. I'll let you hear a little bit on this. So Judge, model probation is going to stand in front of you in handcuffs, just to start off with that. Had he been a model probation, we would not be having this hearing today. Mr. Rice already got a huge break, and it's one that I regret now. This was 2 DUIs. They were both pretty bad DUIs. One of them was a 3-vehicle wreck. The other one, he was basically blacked out at the wheel. He was going to enter into accountability court, and that didn't work out. And I did something that I don't ordinarily do. And like I said, I regret it. I let him withdraw his Stinson plea and come in here and plea under the terms that he pled to. If I had it to do over again, I would not do that. While Mr. Rice has been on probation, I'll concede that him and Ms. Wood have gone through what apparently was a pretty bad breakup. But Mr. Rice handled it poorly, to say the least. Hundreds of phone calls to Ms. Rice. to Ms. Wood, hundreds of phone calls. We have the phone logs here. We can put them into evidence. If you need to have Ms. Rice put them in, Tom, or have Ms. Barton, how you want it?
No, we don't need to do that. I mean, there were a lot of phone calls made.
No, I caught that he just entered a plea to harassing communications.
Right.
So-
Rest communication, with phone calls.
I'll kind of go through these with you to kind of put some context to it. So Ms. Wood and Mr. Rice break up in probably about January this year. He's calling her repeatedly. He's calling her at work, harassing her at work. He's calling family members. He's also posting on Facebook. These posts on Facebook are extremely vulgar. And again, I think Ms. Rice probably wants to be heard on this. This is not just a break. This is somebody who's just gone off the rails. And I see you thumbing through these Facebook posts. This is not ordinary behavior. This is not behavior of model probation. This is he's threatening to post explicit photos and videos of her. He's talking about very intimate parts of her body on Facebook. Somebody even tells him, stop. At one point, let me find the thing.
I'm looking at it.
Somebody says, man, stop. And he's like, F that. I'm taking her down with me. We're all going to hell or jail. IDG, I don't know the slang I should have an almost teenager, but basically it says, I don't give a F word. What happens? And I think he's shown that by his behavior. I can't prove it. But he obviously has a drinking problem. I think this is very alcohol induced. Ms. Wood will certainly testify to that, how drinking was a big part of this. We have 2 DUIs. I think this is probably continued substance abuse. This girl is terrified of him. She's terrified of him to the point that she had to go hire Mr. Sellers, who's obviously here today, to go take out this TPO from Judge Miller. While this TPO was issued in March, and then Mr. Rice immediately violates it by sending her a text. You have the text there. The text even says, I know you took out a TPO and this is violating it, but, and goes on keep communicating with her after she very clearly said, stop communicating. After a Superior Court judge said, stop communicating with me. He continues doing so. Another point I want to make here is Mr. Rice was aware that he had a probation warrant. Ms. Matthews, when was this warrant issued?
1 second. Judge Esri signed it on March 14th.
Okay, so this probation warrant was signed March 14th. Mr. Barton's office reached out towards getting a walk-in hearing on this, and I said I wasn't willing to do that. He needed to turn himself in. Rather than turning himself in, he violates, so he's got the warrant March 14th. Rather than turning himself in, he picks up a new charge by violating the Superior Court judge's order by continuing to contact Ms. Wood. He was not going to stop. The only reason he stopped is because he physically can't do it because he's in handcuffs at the jail now. Otherwise, this harassment with Ms. Wood would continue. This is not fair to her. It's not fair to her at all. She's terrified of this man. I think the response here, given he's already got a huge break, as I said earlier, I would not offer him the offer that I made again, and I regret it. He doesn't deserve another break. He does not. And we're asking you to revoke the balance. And again, I think Ms. Wood probably wants to be heard on this if you'd like to hear from her.
Sure. All right.
And I think Mr. Sellers may have something he'd like to add also.
Judge, I object to that. But this is not a divorce case.
Ms. Wood has a right to be heard. She is the victim in this.
Ms. Wood has a right to be heard.
Yeah.
So the objection to Mr. Sellers' testimony is sustained, but Ms. Wood does have a right to be heard.
Right, absolutely.
And what we'll do is we'll put her next to Mr. Sellers over there. Where's she? All right, so she's back in the back. If she wants to testify, she can pull up a seat, use the microphone next to Mr. Sellers.
You want us to move back over here?
Yeah, that's fine. So if y'all just move over to your
Have
seats.
her sit here, Judge?
Yes, because that way, otherwise, Director Matthews, no, it's fine. I'm also creating a couple of barriers. So, and letting her sit by her attorney. All right, for record purposes, Ms. Woods is here seated at the state's table. Mr. Sellers is her private attorney. He will not be speaking in this moment for this purpose, but he will be sitting with her during her testimony. Mr. Shepherd, the floor is yours.
Ms. Wood, will you raise your hand, please? I swear the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. All right, so you gotta speak up, so Ms. Kathy here is taking down everything you say, so she's gotta hear, and the judge also needs to hear what you're saying. Okay?
And that microphone will get really loud if you just get really close to it.
Okay.
All right, can you state your name, please?
Kristen Danielle Wood.
All right, Ms. Wood, were you previously in a relationship with Mr. Stephen Wright?
Yes, sir.
And And y'all have children together?
One
One child? Boy or girl?
boy,
How old?
3 years old.
And that's Mr. Rice, seated over here at the defense table, correct?
Yes.
When did that relationship end?
I finally moved out on January 11th, 2025. We have been on and off for the last 3 years.
So after the relationship ended, have you had issues with Mr. Rice harassing you?
Yes.
When did that begin?
January 11th, 2025.
So the day of the breakup?
Yes.
Did you contact law enforcement about it?
Yes, sir.
Do you recall the first time you contacted law enforcement?
I want to say it was January 12th, 2025. Do I continue? No. He showed up at my house 3 different times, like back to back. He came, I asked him to leave. I threatened to call the cops, so he left. He was gone, and then he came right back. I pulled out my phone. I actually called the cops. He left, so I told the police. He left, and it's okay.
Judge, I'd object. We're going outside the scope of the charge. If it has to do with the harassing communication charge, that's fine. If it has to do with the violation of the TPO charge, that's fine. That's what's on the table here today. I know they've had a bad relationship and it went south, and we don't really, I don't think, need to hear all of that. I think this witness should be confined to the charges that are before the court today.
So I'm going to meet in the middle. So Mr. Shepherd, I'm going to give you a little more latitude. I do want this to be connected to the 2 pieces.
I'm going there.
And so I'm just going to give you a little bit more space, but do land that in that space.
I'm coming down with it. Yes, sir. All right, so were there other times that you called law enforcement?
Yes, sir.
Okay. You recall how many times you called law enforcement? Roughly.
Roughly 4 or 5 times.
Now, I'm going to jump to March 7th. Did Mr. Rice contact you on that date?
Yes, sir.
Now, you've provided some phone records, is that correct?
Yes, sir.
I'm going to hand you those. Do you recognize those?
Yes, sir.
What is that?
It's my phone log.
All right. Is that the phone log from your personal cell phone?
Yes, sir.
How did you obtain that?
I screenshotted it.
Is that a true and accurate screenshot of your call log for March 7th of 2025?
Yes, sir.
Now, some of those calls say Stephen. Is that Mr. Rice?
Yes, sir.
Some of those calls say private number. Do you also believe that's Mr. Rice?
Yes, sir.
Why do you believe that?
Because I answered quite a few of these phone calls, and every time I did, it was Stephen on the other line every time. So I just started ignoring them, or just started answering and begging for him to leave me alone.
And did you told him to quit calling you?
Yes, sir.
All right. Did he quit calling you?
No, sir.
Now, have any idea how many calls you made March 7th, March 8th?
Roughly March 7th to March 8th.
Yeah, just what you got there in your phone log. Is it in the single digits, the
Triple digits.
triple digits? What hours was he calling you?
Middle of the night, early morning, midday, all day long, every single hour, every 2 minutes, every 1 minute. My phone has never went off so many times in my life.
All right, Ms. Wood. I'm going to show you another document. Did we tender those, did you stipulate those?
The one about the
The
TPO?
phone log?
No,
No,
the judge
nothing
has
was-
those.
Nothing, I passed them back now.
Well,
Nothing's
I'll
been
tender
tendered.
those as State's Exhibit 1, the
Right,
phone log.
no, Judge, that's been previously provided to me by the state, and I had a chance to review it.
All right, does that include everything you passed up or just the phone?
Just the phone log.
Okay, phone records of State's Exhibit 1 is tendered and admitted without objection.
Right, that, yes, Judge.
All right, I'm going to show you what I'm going to mark as State's Exhibit 2. All right, Ms. Wood, do you recognize that?
Yes, sir.
All right, what is that?
That is Facebook posts that Stephen made about me.
All right, how did you obtain those?
I got screenshots sent to me from my sister.
All right, Do you have a Facebook account?
I do.
Are you familiar with what Facebook accounts look like?
I am.
Are you familiar with what Mr. Rice's account looks like?
Yes, sir.
Do those appear to be true and accurate screenshots of Facebook posts made by Mr. Rice?
Yes, sir.
Yes?
Yes, sir.
All right, I'll tender that as State's Exhibit 2.
Objection?
No objection, that already been passed up to you, I think.
All
I'm
right.
just trying to make sure I'm checking boxes.
States 2 is tendered admitted without objection.
All right, so Ms. Wood, in some of those, do you take those to be threatening posts?
Yes, sir. I felt threatened.
And were those made at roughly the same time as these calls were made to you?
Yes, sir.
All right, so did you seek a TPO against Mr. Rice?
Yes, sir.
Why did you do that?
Because I felt scared every time I walked out my door. I've never locked my door. And as soon as I left, I locked the door as soon as I shut it. I shut the front door and the deadbolt got locked. I was scared to leave my job. I was scared to go to work. I needed to work. I now have a 3-year-old on my own. So I worked as often as I could, but at the same time, it was hard to go to work. I had people coming into my job who seen all of these posts about my body, about my life, sitting in my section. I've had to give them away. I've had Steven's family sit in my section. I've had to give them away to another server. I had to remove money from my son's pocket because I can't stop shaking long enough to do anything.
All right, Ms. Wood, I'm going to show you Martha State's Exhibit 3. Do you recognize that?
Yes, sir.
And what is that?
That is the protective order,
When was that dated?
March 25th, 2025.
And is that the protective order that you sought and obtained, preventing Mr. Rice from having any contact with you?
Yes, sir.
I'll tender that as State's Exhibit 3, Judge.
Objection?
Public record, no objection.
All right, States 3 is tendered admitted without objection.
So lastly, Ms. Wood, I'm going to show you what I've marked as State's Exhibit 4. Do you recognize this document?
Yes, sir.
All right, what is that?
This is the text that Steven sent me on April 7th or April 9th.
Does April 9th sound right?
Yeah.
Is that a true and accurate copy of the text that Mr. Rice sent to you?
Yes, sir.
All right, I'll tender that as State's Exhibit 4.
Objection?
No objection, Judge.
All right, States 4 is tendered admitted without objection.
All right, and was that text was sent to your personal cell phone?
Yes, sir.
That was sent after you had told him not to contact anyone?
Yes, sir.
And that was sent after Judge Miller signed a protective order telling him not to contact you?
Yes, sir.
Are you scared, Mr. Rice?
Yes, sir.
Do you believe Mr. Rice was drinking during any of this?
Yes, sir.
What makes you believe that?
Because I've seen him act this way in person. I've heard him through the phone. Every single time it has happened, he has been drunk. I believe somewhere deep down in his body, he loves me. But with the alcohol and with just the way that things have happened, that he's not allowed to actually. I think that he's crazy about me. He's obsessed about me. And it shows and it continues. And I do not think it will stop.
That was going to be my next question. Do you think he's going to stop trying to contact you?
I do not. The day this order is over, he will text me. The day this order is over, he will phone call me and he will come to my house. And he will come to my work and he'll do anything he possibly can.
Thank you, brother. I don't have any further questions, Judge.
Mr. Barton has the right to ask you a few questions, ma'am, so take a couple of deep breaths, and Mr. Barton's going to ask you a few questions.
Very few. I only have a couple. I don't bite. And my name is Tom Barton. I'm here for Stephen. Just very briefly, how long have y'all been a couple? in a relationship?
It's been on and off for 5 years.
How old are you?
I'm 32 years old.
Okay. How old is Steven?
He is 33 years old.
You kept the same phone number through all this,
Yes, sir.
and you actually blocked him so he couldn't reach you anymore at some point, right?
Yes, sir.
And then about the 7th of March, you unblocked it, right?
Yes, sir.
And allowed him to contact you for a little bit,
Yes, sir.
and then I assume you reblocked him again. Is that right?
Yes, sir.
Okay. A couple of days later.
I believe so.
Okay. All right. Maybe March 9th or 10th or something like that. Okay. That's all the questions I have, Judge.
All right, any redirect?
No, sir.
All right, if y'all will pass your exhibits up, so I can get my deal. Thank you. All right, and for record purposes, I'm in possession of all 4 states' exhibits. Okay, Mr. Shepherd, anything else?
No, sir, Judge, I don't have any more evidence to put up.
Okay. All right, Mr. Barton, do you wish to put up any evidence? in
No evidence,
mitigation?
just argument, Judge, when you're ready.
All right, Mr. Shepherd, you can go first, last,
I'll
both.
go last, Judge.
All right, Mr. Barton, floor is yours.
Judge, thank you very much. Couple of items here. Number one, when you go on probation, you are drug and alcohol tested. You're drug and alcohol tested with an ETG test. It's a metabolite of alcohol in the urine. It hangs out 10 to 12 days after a drink. If you get 3 tests a month, there's no way to dodge it. Judge, my client's been on alcohol testing for these 2 DUI cases since November. He's never failed a drug test or an alcohol test. So there's no evidence that he consumed any alcohol at all, other than a very bitter and mad ex-girlfriend. So you have to take that in consideration. Number 2, Judge, we didn't try the harassing phone calls case. And based on the questions I just asked, I think the court probably picked up on my point. Judge, the code section is 1611-39.1, and it prohibits, harassing phone calls and defines it as repeated calls over and over and over again, all right? It also says calls that could be taken as threatening or annoying, okay? Even annoying calls. Judge, the phone calls that you have, I would have argued and asked for a directed verdict from the court at trial if the evidence was just repeated phone calls. The basis of our plea to the harassing communications charge really are the Facebook posts. Those are annoying. Depending on how you interpret it, they could be somewhat threatening. I'm not sure. It'd be up to a jury to decide. But if it was just the volume of calls, 100 calls in the 2 days, the witness stated very clearly that she had him blocked, and then she unblocked, and then she reblocked. Okay, so really this statute with modern technology now is almost irrelevant and almost inapplicable. Because if I don't want to talk to you, all I got to do is pick this thing up and go, whoop, and you're not going to talk to me because you can't get through to me. So by unblocking Mr. Rice, she invited and consented to those calls. Now, when she'd had enough, she did exactly what she had the right to do, and that's block him again. Okay? And if that was the only evidence, Judge, in the case, I probably would have taken it to trial on that. I think I'd have been entitled to a directed verdict on it. But we didn't. We pled guilty to it, Judge, and that goes to my next argument. Judge, we've come in and taken responsibility for the immature and emotional Facebook posts and for the violating the TPO. The exhibit that the state put up is a Facebook post where he goes, "Hey, I know I'm violating the TPO." So he was, hey, he's not hiding anything from anybody. Okay, he's not. So, Judge, he's been taking responsibility for the immature emotional behavior in this breakup. It's almost like a couple of high school kids breaking up, and he's been been sentenced to that. He's got 24 months of probation where the court can make sure that he doesn't have contact with her. And I think we agreed to evaluation and counseling in that same sense, which would be valuable and helpful, obviously, how to handle family divorce, basically, and so that's, in other words, he's been punished for that, Judge. He's been held accountable for that now. The court's done that already. Question before the court is, how bad of a violation of his DUI probation is this? Okay, had he tested positive, then we'd probably have a real big problem. Had he failed to go to meetings, had he failed to get his evaluation, had he failed a drug test, had he committed a new driving offense, a new alcohol-related offense, then, I think a balanced revocation might be appropriate. But Judge, that's not the case here. And as sympathetic as you may be, and we all are to the ex-girlfriend, okay, if this were a divorce case and both sides got to put, and I'm sure there's stuff that can be said on both sides, but we're not getting into that. Okay, we're not getting into that. The only decision for the court is how egregious is a harassing phone calls case and a TPO case as related to a DUI probation. Judge, he's been in jail now for 45 days or so. He's done well. I've provided good character evidence to the court. And if you want me to tender that as an exhibit, we'll certainly make that exhibit one, tender it to the court as our exhibit.
Okay, then I'm going to take the entire packet you passed up to me, which is multiple letters. I'll make it defense exhibit one.
Right.
Tendered, admitted without
Judge,
objection.
he is a very hardworking and capable person that has a job waiting on him and can provide for 2 children, not just one. I don't think there's a child support order in place yet on the child with this witness. I'm sure Mr. Sellers will be working on that diligently shortly. So if we leave him in jail for a few years, nobody's getting any support here, Judge. It's not appropriate to revoke the balance in this case. It is appropriate to let him back out on probation, put restrictions in place, and let him work, support this child, get some counseling, to learn how to deal with this very emotional breakup. Thank you, Judge. That's all I have this morning.
Thank you, Mr. Barton. All right, anything else from anybody before you have the right to respond?
I said most of my piece earlier, Judge. Again, he received a huge break on this up front. He's shown a pattern of really, really concerning behavior while on probation. He's also shown that he's completely willing to just disregard what a judge orders him to do. Judge Miller ordered him to have no contact with Ms. Wood. And what does he do? He just ignores it and reaches right back out to her. I have no confidence. You heard Ms. Wood just a few minutes ago. I have zero confidence that he's going to leave Ms. Wood alone. I think the appropriate response here is to revoke the balance, Judge.
All right, thank you. All right, any other housekeeping before I make my decision? Okay, the procedural posture is of the case. I have 2 matters before me that I need to decide. 24 SR 1097, which has, I have it right here, 546 days remaining. That's the case that's currently ticking forward. Pending and waiting initiation is 23 SR 812, which has 728 days. It has not begun yet. It is still pending. We just entered the 2 pleas on 25 SR 660, which is the family violence order, first offender, 12 months probation consecutive to 812, and 25 SR 471, harassing phone calls, 12 months probation consecutive to 660. So I'm just making certain that what I'm looking at and what y'all expect me to look at are the same. Is that correct, Mr. Shepard?
Yes.
Mr. Barton?
Yes, Judge.
Okay, great. So the first one, 24 SR 1097 is very easy for me. It's revoke the balance, no discussion. I mean, there's no other way I would ever consider anything different. So on that one, so I'm gonna pass that back to you. I did not fill it out. So on 1097, it's revoke the balance.
What's the number of days on that, Judge?
546, I believe, was the number.
That's what I had.
On 812, I am conflicted only because Not that he deserves leniency, because I'll go ahead and tell you, when I looked at these Facebook posts, it just became very aware that of something that we've always talked about in this courtroom and in us in the legal community. When you have folks in an intimate relationship, they have information on us that no one else in the world has. And there's a responsibility to not air that information to the world in a spiteful manner. And I was horrified when I saw these posts. They are incredibly intimate. They talk about incredibly sensitive things. And frankly, the thing that got me more than anything else was a posting of a picture. Now, the picture in and of itself is not, it's not inherently inappropriate, but the context tells me that there's more. The context, it felt when I saw it that, hey, guess what I have a treasure trove of and that I'm getting ready to cut loose. Now, I'm annotating that picture with my own impression, but I am saying that was the moment where I went, oh, okay, I see how this could go badly. And then obviously there are multiple references to very intimate acts that they did together when they were together. Then obviously we have the protective order and the violation of the protective order from Judge Miller. So with that said, it would be very emotionally satisfying for me just to revoke the balance, because that would be easy to do. What I'm worried about is I revoke 728 days. He does about 30 of those or whatever, and then we're back to square one. And I don't think that's in his best interest, and I don't think that's in her best interest. I don't think that sets them up for a future. And so, frankly, I'm about to do something which is he's not going to like at all, which is I'm about to move the second case out to probation, but the contingencies and stringencies that you're about to face, you're frankly going to wish I had just left you in jail. Because you're going to have about 1 inch on either side of your foot while you're walking before they take a warrant and just put you straight back in the jail, and then I'll just revoke all of it, every bit of it. And so here's what I'm doing in 812. The short answer is that he is to report as directed. He will report weekly during the duration of his active probation. He will waive any evidentiary foundations for admissions of drug screens. Payments I will leave up to sentence enforcement to sort out. He will be on zero tolerance on 23 SR 812 for the duration of active probation. Now, the attorneys instantly understand that, but what that means to you, Mr. Rice, is if you step out of line even an inch at any point during 23 SR 812, then I'm going to take a warrant first and I'm going to figure it out second. So if Mr. Sellers reaches out to Mr. Shepard and they find that there's probable cause, of course, that there's something here, I'm going to sign a warrant first and then we'll sort it out later. Your report date will be within 72 hours of release. So you must report in person within 72 hours of release. Now, I don't believe you completed the DUI responsibilities, because I'm catching that I'm revoking these times. So
I believe
he just
did.
has to get a license, and I'm not catching that he did the things he needs to do to get a license.
He's done DUI school, he's done the substance abuse evaluation.
Okay, fantastic.
I think we did everything. I
Okay,
mean,
then I'm just gonna
we
put-
direct that, so.
All right, then
we
I'm just
probably
gonna
had that done before we even came to court.
All right, then I'm just going to put license. Now, the end of this and what my goal in putting him on here is no contact with Kristen Wood. Now, the key to this whole thing that my plan is I'm anticipating by the time he gets out, Mr. Sellers will have gone to Superior Court and gotten orders controlling how their relationship is going to move forward in the future, because we have a kid involved in this and we have them involved in this. And so I'm going to put on here that he is subject to any Superior Court order involving these parties. I guess it could be Superior or Juvenile.
Yeah, I guess it's supersede anyway, right?
Yeah, so subject to any Superior or Juvenile Court order involving these parties. and because my handwriting is horrific, Director Matthews will probably have to retype this, and I'll sign another one later, because I can see the look on her face. Subject to any Superior Juvenile Court order involving these parties. Which means that if he gets out and he doesn't, you're saying he's got to get out and do child support. So if he gets out and doesn't pay his child support, like, that's an order involving these parties. And that's one of the reasons I'm considering this, is because I want to know, has he really learned his lesson? Is he really going to be a grown-up here? I'm trusting that you are, Mr. Rice, but I'm making certain that if you're not, I have all the teeth I need to respond instantly to anything that's out of the ordinary. So, all right, Director Matthews, anything on this that's going to make your life easier? Okay, sorry about my handwriting.
136 days.
All right, Mr. Shepherd, is there anything else in my decision? I know I didn't do what you wanted me to do, but is there anything else in here that just absolutely needs to be addressed that I have not addressed, other than not
My main
doing?
concerns, Ms. Wood.
Okay.
I think you addressed that, him staying away from her and her place of employment and her family members.
Yes, I just have no contact with Kristen Wood, and obviously I'm interpreting that in the broadest possible sense.
To make sure it's very clear, because there are issues with contacting family and employment, and that any contact, if he calls her at work, that will be considered as an effort to contact her.
That's correct.
Did you ever legitimate this child? She's not your child. Right.
I'm also anticipating a potential Superior Court order that controls legitimation, child support, custody, whatever that is. And so my point is we're gonna follow whatever that is. If it says no custody, then no custody. If it says custody and visitation, he gets custody and visitation.
There's nothing now, to my understanding, he is not legitimated a child
Right.
yet.
Okay, well, I'm just saying by the time he gets out, I'm anticipating some of those matters will be addressed. And that way I don't have to guess as to what they will be.
Sure.
All right, Mr. Barton, is there anything in here that I have not addressed that just needs to be addressed on here?
No, Judge, we just appreciate you listening to us this morning.
Okay.
And as we always do, we appreciate it.
Well, it's a pleasure to have you down here, Mr. Barton, but I think, and yes, thank you for that. And I think we're all on the same page. The goal here is peace and tranquility. Ms. Woods needs to be able to leave her home and go to her work without having to interact with anybody, including. And of course, Mr. Rice, you don't control your family, but obviously if your family creates trouble and then there is a link back to you, they are not the ones who will be in trouble. You will. So you might want to have a very serious conversation with your family that they need to be very careful what they do. Because there is a scenario where it could come back to you and none of us want that. Okay. All right. So, Mr. Shepherd, anything else?
No, sir.
Okay, then that's the order of the court. Mr. Barton, let me give you these to sign and have your client sign.
Approach, John?
You can, of course. All right, and let's go off record while we get reset for our next hearing.